Welcome to the WN Legal Podcast.
Welcome to WN Legal's podcast. My name is Khew, and today's podcast will be talking about the Family Violence Court and the circumstances surrounding bail when the victim and the accused are in a relationship and they have reconciled after the dispute that gave rise to the prosecution of an offense. So whatever I say, whatever is discussed in this podcast, I have to repeat again, it does not constitute as legal advice, and I would recommend that you speak to a federal legal practitioner before you do follow through with anything that's said in these discussions. I do not have an intention to make it a binding legal advice to anyone whatsoever. It's just general discussion about the law. So to elaborate what I've been trying to say about this topic, it's what happens if an accused person has been charged after a domestic dispute with their partner, and they have reconciled after the dispute, but the dispute gave rise to a charge. Maybe it's assault, breach of violence restraining order conditions, or anything related to a domestic dispute. Now, if a person is charged with assault or any related offenses that occurs because of separation or an argument between the partners in a relationship, the accused is entitled to actually enter into a court program called the Family Violence Court Program. Now, this program is mainly aimed to rehabilitate the accused persons. As far as I'm aware, I may be wrong, and I put a caveat on this. But as far as I'm aware, the Family Violence Court is a relatively rehabilitative court program, and what they do is they aim to allow the offenders to gain an insight towards the offending in domestic circumstances. So these programs are aimed at ensuring that the offender, when they actually are charged, to allow them to have an opportunity to go through court-based counseling programs. These programs, they last from perhaps 6 months to 8 months, and sometimes even a year. I had a gentleman that had been in there for quite a long time. But usually it's about 3 to 6 months. But these programs require the offender to first enter a plea of guilty and admit to the offense, or an anticipated plea at least. But as far as I'm aware from practice, usually the offender would have to enter a plea of guilty before they can be assessed to enter into the Family Violence Court Program. If you don't intend to plead guilty because you do not agree with the charges, you should seek legal advice, because this podcast is about the program and the processes in the Family Violence Court. And that's predominantly around entering a plea of guilty and going through the court program. So how do they work? The Family Violence Court is not, it is as it says, it's about family violence. The offending type of behavior, usually they are revolving around assault occasioning bodily harm, or anything, or any actions or conduct that would occur that is illegal out of a dispute between the parties. Breach of violence restraining orders can also fall into this category. So when a former partner they've instituted a restraining order application against the accused person, and the accused person starts text messaging. That happens quite regularly. We have to be very careful there because there's a 3-strike rule for violence restraining orders. So upon 3rd strike of breaching a violence restraining order, prison terms, a term of imprisonment is something that the court will consider and can consider. There's actually a new a new law that came about in the Restraining Orders Act about the 3-strike rule. I would recommend that you read up on it as well. But the family violence court program, when an accused goes into this program, they are actually either listed at first instance by the court or the prosecution because they categorize the offending behavior as one that arises out of a domestic dispute, or the accused person who is charged and is appearing in court can also elect to enter into the family violence program, because sometimes the court or the police prosecution cannot just identify that the offending behavior came out because of a domestic dispute. Certain charges can't go through the family violence program, most notably indictable offenses, because they need to go to the district court. Indictable offenses are offenses, they are serious, and they carry a more significant term of imprisonment. They can't be dealt with by the magistrate's court. They would have to be dealt with in the district court. And for that reason, the family violence program cannot entertain offenders with indictable offenses. The family violence program is usually for summary offenses or either way offenses that are not elected to be prosecuted in the district court. So once you enter into, once you're in the family violence court, usually lawyers will provide you with legal advice and see whether or not you agree to the facts or the circumstances of the case as alleged. If you do agree, then you can choose to either enter into the program or choose not to and be sentenced forthwith. If you're sentenced forthwith, then obviously you don't have the opportunity of and the privilege of participating in the family violence program. They involve counseling sessions and also various other program requirements that I'm actually not aware of. They may involve other program requirements. But when the offender goes through with the program, they first have to either endorse a plea of guilty or enter a plea of guilty. Usually, in our practice, we would provide a very comprehensive legal advice to the client, because if you enter a plea of guilty and you go through the program and at the time of sentencing you say, oh, I don't agree with the facts, then that is actually an issue. You must first seek legal advice before you decide to enter a plea of guilty to a charge in any event. And once you go through the program, then the court will sentence you at the end of the program. The court will receive a report and see how you or the accused person, the offender, has actually progressed through the counseling sessions. Now, there are times when the offender or the accused person has actually reconciled with the victim, the partner, or if not reconciled, the offending behavior occurred out of spur of a moment, and both parties acknowledged that the offending behavior was unbecoming, but it was a one-off, and they want to reconcile. That is a problem, because when you're charged, there's something called a protective bail condition that's in the Bail Act, wherein the accused person cannot contact or communicate with the victim. So because of a dispute and something that happened and that was wrong, the prosecution of that case would warrant the accused person not speaking, would prohibit the accused person from speaking with the victim. That is a problem in itself because usually they live together, and the protective bail condition would require the accused person to move out. That is a problem for many, many people, but unfortunately it's something that is an issue in this time and age, and with these court processes. A lot of the times, the court will be asked to vary the bail conditions, the protective bail conditions, so that the accused person can speak to the victim. Now, I would have to say this with an abundance of caution, because not many of these bail variations will succeed. The court will first need to ask for a bail assessment report. The bail assessment report will cover all the issues that the court will consider relevant if they were to revoke the bail conditions. Now, after receiving this report, and this report is done arbitrarily by another person, that's not us, not the defense lawyers, it's done by another person, and this author of this report would then endorse to the court or recommend to the court whether or not the bail should be varied or revoked or cancelled. If they say no, it should not be cancelled, more often than not, the protective bail conditions will still stay. Now, a lot of the times that these offending behaviors occurred out of the spur of a moment, or in fact, the victim has actually not told the actual event of what happened at the time of the dispute. They may have, out of anger, told the police things that are favorable to them, but not the actual entire case. Now, unfortunately, that is a dispute of fact. That is a matter that may need to go to trial if the victim's case is not marrying with the actual fact of what had occurred on the night, and even if they don't marry, whether or not there's an actual defense to the assault charge, the defense by Part 2 of the Criminal Code, or the dispute of fact would mean that the assault didn't actually occur, or the act as alleged did not actually occur. If this is the case, then I don't think it's appropriate for the accused person to actually go through the court program, the family violence court program, but to consider whether or not they should enter a plea of not guilty, because there may be either a trial of issues or an actual trial on the dispute of fact, or a trial with a defense to be invoked by the accused. So these are things for the accused person to consider, despite the fact that they are in the family violence court program. They must also consider whether or not they have a valid defense. If they don't, upon being provided with comprehensive legal advice, then they have to consider whether or not they want to go through the court program. Okay, so this ends today's podcast. I hope I've enlightened you a little bit more about what the Family Violence Court Program is about, and in circumstances where a domestic dispute would give rise to a prosecution of an offense against the accused person. Thank you for listening through.